Hi there, I'm Christine, and this is the Canadian Constitution Foundation's Freedom Update. This week, we received the long-awaited result in our legal case challenging the British Columbia government's vaccine passport regime. While those vaccine passports have not been in force for a few months now, it was still important to go through this case and get a decision because the BC government has always said that there's potential for them to bring back this policy. So the news I'm sharing today on the result is not the news I wanted to share with you because unfortunately we did not win this case. But in this video, I'm going to break it all down for you. If you're new here, welcome. My name is Christine, and I'm the Litigation Director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. And please remember that nothing in any of my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So on September 12th, Chief Justice Hinkson of the BC Supreme Court issued his decision in the Canadian Constitution Foundation's legal challenge to the BC government's vaccine passport regime. I will link to the full text of the decision below in the description so you can read it for yourself. To summarize what happened, if you'll remember, this case was brought by the CCF as a public interest litigant, as well as by 3 individuals who could not be vaccinated because of medical reasons. The first was a teenager who developed a form of heart inflammation called pericarditis following her first dose of a COVID vaccine. The second patient was a pregnant woman in her 30s who developed an adverse reaction called brachial neuritis, which left her arm paralyzed. And that was a reaction to the first dose of a COVID vaccine as well. The third patient was a woman with complex and overlapping disabilities. She has a condition called spina bifida, which leaves her mobility impaired. She also has had about 15 surgeries in her life and has a history of very poor surgical outcomes, as well as a history of multiple adverse drug reactions. She uses the pool, a swimming pool, for physical therapy, but because she is unvaccinated, she was denied access because of the vaccine passport regime. This woman was not vaccinated because of her concerns about her unique and very complex medical profile. And all 3 of these women were denied access to all kinds of different public spaces because they were unvaccinated and because of the BC government's vaccine passport regime. We brought a legal case challenging that regime for failing to have a functional medical exemption system. However, the court dismissed the case as premature, finding that all 3 individuals who brought the case around medical exemptions had not exhausted their opportunity to apply to the Public Health Office for a medical exemption. This was very frustrating because if you read the orders that created the vaccine passport regime, and if you take those orders at face value, there really was no ability for these women to apply for blanket exemptions. We argued that the BC orders had created what we call a closed list of conditions that were eligible for medical exemptions. And 2 of our petitioners could not even apply under that closed list because their conditions were rare and didn't appear on it. The teenage girl with pericarditis was only potentially eligible for an activity by activity exemption, which meant she would need to apply to the government every time she wanted to do some basic socializing in public. And in her application to the government, she needed to explain the importance of the activity she wanted to engage in and why she couldn't do that activity at home or virtually. This is totally an outrageous micromanaging of the day-to-day life of a teenage girl who is experiencing a new and painful disability. But the government evaded constitutional review in our case by filing evidence that they had been accepting medical exemption applications for conditions beyond those in that closed and limited list in its mandatory application forms, and that they had been granting general blanket exemptions despite the Public Health Office orders, which stated that only activity by activity exemptions would be granted. All of this only became known 4 months later when the CCF lawsuit had forced the government to file evidence in this case. Essentially, the government defended an unconstitutional order by saying that they secretly didn't actually follow their own rules, and then faulted the patient petitioners for not having known this. The 3 women in our case were in an impossible situation. In our view, at the CCF, it was obvious that the BC government passport regime set out in the public health orders and in the mandatory forms did not have an open category for medical exemptions. And BC healthcare professionals, like doctors, were dissuaded by their regulator from writing letters in support of exemptions on the basis of the Public Health Office's own statements that only listed conditions would qualify for an exemption. The result was that these patients couldn't find physicians who would write supportive letters for the medical exemptions, even when these same physicians would write supportive letters for other purposes, like employment purposes. All of this is wrong, frustrating, and extremely disappointing. As a result of this finding, Chief Justice Hinkson did not resolve the 3 petitioners' arguments regarding charter breaches because of this finding of prematurity. We had argued that the BC vaccine passport policy violated these 3 women's charter protected rights to equality and to security of person because it was unnecessarily coercive. This result is extremely frustrating for us, and I'll be honest, I was very upset yesterday when we received this result, and I needed to communicate it to our individual applicants to these 3 patients. My heart really goes out to these 3 women and to other people who are in similar situations who suffered from social isolation and from the high-handed treatment by the BC government because of their disability. I also want to take a second to thank these 3 women for participating in the case, because it takes so much courage to put your name forward and participate in public interest litigation. These women were already dealing with complex and, in 2 of the cases, brand new and painful medical conditions. But they still made this case a priority, which was to the benefit of all Canadians. So thank you so much to all 3 of you for participating in the case. I also want to say thank you to our lawyer, Jeffrey Trotter, who did an amazing job in this case and who shares my frustration over the outcome. We are still discussing the next steps about this case internally, including the possibility of appeal that would need to be filed within 30 days. So be sure to stay tuned and I'll have more information later. If you want to learn more about this case, I'll leave a few links in the description below, including other videos that I've done related to this case and some articles that I've written about it. And if you want to stay up to date about all of our ongoing cases, including our legal challenge to the federal government's invocation of the Emergencies Act, you can sign up for our email updates, our freedom updates at theccf.ca/freedom updates. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.